All right, we are live just in time. Excellent, excellent. So welcome everybody. I just got this across my news feed and I had to go live with it immediately because it's huge news. I think it's what a lot of us expected. It looks like fair use and transformation and even the Matt Haas H3H3 case all come into play here, and the judge does a great job with the summary. So I am just going to jump right into it. This is in the District Court for the Southern District of New York. This is the Akilah Hughes case versus Carl Benjamin, who is Sargon of Akkad. Now, Akilah had, I guess still has, a YouTube channel called Akilah, obviously, and Carl Benjamin, I think he still posts. I think I saw videos just from a month ago. But this was so long ago. This was filed back in 2017 is what this number means here. So really interesting case. Let's get straight to what the judge has to say. This is Judge Richard J. Sullivan from the Southern District of New York writing. Plaintiff Akilah Hughes brings this action against defendant Carl Benjamin and John Doe defendants for copyright infringement and misrepresentation. That's going to be part of this because that's what I tell everybody to do when they get a DMCA claim that they believe is false. They go on to look into this Section 512F of the Digital Millennium Copyright Act. She alleges that Benjamin's YouTube video, SJW Levels of Awareness, unlawfully copied Hughes's YouTube video about the 2016 presidential election. We thought she should win. So Akilah posted the video, we thought she should win. Now, before the court is Benjamin's motion to dismiss the complaint in its entirety. So he filed a motion to dismiss. This is what you do when you believe that there's no claim that's made that a court can recognize. And so a fair use claim that negates the copyright claim would be something you would file a motion to dismiss on, as opposed to necessarily going to a summary judgment motion, although that also happens, and that's what happened in the Matt Haas H3H3 case. So the judge says right here at the beginning, so you know already what's happening, for the reasons set forth below, the motion to dismiss is granted. And it's even worse than that. The judge does not give her leave to amend and try to overcome the motion to dismiss, which you normally do get at least one chance to amend. So the judge goes into the background, which is why I'm not going into any background. Hughes is a popular content creator and filmmaker who maintains the YouTube channel Akilah, obviously. This is a split column decision, so we're going to read the left column first, and then we have to go all the way back up to the right column, and so that's what we're going to be doing for these 10 pages. Her work covers a broad range of topics, including comedy, race, social commentary, feminism, beauty, and fashion. On November 8th, 2016, the night of the 2016 presidential election, Hughes filmed Hillary Clinton's campaign party at Jacob Javits Convention Center in Manhattan. 10 days later, Hughes posted a 9-minute and 50-second video titled "We Thought She Would Win" to her YouTube channel. The video contained her campaign party footage as well as her thoughts of the night's events, both during the night and after the night was over, including commentary on the implications of Secretary Clinton's defeat by now President Donald Trump. The video begins with Hughes at the Javits Convention Center early in the night, stating that she is really excited to be a woman in the year 2016. After having a black president for 8 years, we will now have Hillary, who could potentially be our next president. The video then cuts to Hughes reflecting back on the election night after Secretary Clinton's loss, noting that no one thought she wasn't going to win. So it started out very exciting, just full of hope, before the mood just crept down until forever. The final 5 minutes of the video consist of wide-ranging commentary, including Hughes urging her audience to stand up before violence is committed against minorities, her negative feelings toward the year 2016, and her gratitude for being surrounded by like-minded people in New York City. Hughes alleges that she is the sole owner of the video and that it is registered with the Copyright Office, so we don't have that at least. I'm just going to go back here to this footnote number 1. In ruling on the motion to dismiss, the court has considered the complaint, the YouTube counter notification from Sargon, which are, and the original and allegedly infringing videos incorporated by reference. So in other words, those are the only things the judge has considered. The final 5 minutes of, we read that already. The allegedly infringing work. SJW levels of awareness. Benjamin, like Hughes, is a content creator and filmmaker who maintains the YouTube channels Sargon of Akkad, The Thinkery, and I think there's a couple others there. Akkad Daily was one I saw, where he publishes anti-ideological and anti-identitarian content focusing on the left, racism, feminism, Black Lives Matter, and Islam. Benjamin is publicly known for his provocative style and strongly held beliefs against liberal social and political stances. The day after publishing We Thought She Would Win, Hughes discovered that Benjamin had posted the video, SJW Levels of Awareness, comprised entirely of 6 clips of We Thought She Would Win, totaling 1 minute and 58 seconds to his YouTube channels. Now that's really important. Let's remember that his video was comprised entirely, that sounds to me like entirely means entirely, of 6 clips from her videos. So he made his own video out of 6 clips of her video, and so far the judge hasn't acknowledged anything else. He says it's entirely of those 6 clips. And the complaint alleges that the Levels of Awareness video copied 1 minute and 28 seconds from We Thought She Would Win, but then in a review of the work itself, which supersedes and controls contrary allegations contained in the pleadings, it reveals that the actual copying was 30 seconds more than alleged. So the judge even noted that the judge figured out that it was 1 minute 58 seconds, not 1 minute 38 seconds. According to the complaint, SJW is an acronym for Social Justice Warrior, a term routinely used by Benjamin in a demeaning context to belittle proponents of perceived liberal social policies and stances. The Levels of Awareness video begins with Hughes expressing her excitement over the potential election of a female president, followed by a clip depicting her subsequent disappointment over Secretary Clinton's loss. And that's the first 50 seconds of the video. The Levels of Awareness video then cuts to footage of Hughes stating that Trump supporters mean to divide the country, urging people to speak out against bigotry, and observing that 2016 is now somehow the worst year of her life. The video, and that's 50 seconds to 1 minute 48, and then the video concludes with Hughes declaring her appreciation for living with like-minded people in New York City. SJW Levels of Awareness includes no commentary or video recorded by Benjamin. So we're going to think about this, whether or not this is some kind of new precedent or clarifies how things happen or how copyright infringement is interpreted in these kinds of productions. After discovering Benjamin's video, Hughes submitted a takedown notice pursuant to copyright law. YouTube then disabled public access to Benjamin's video, which it has to do. That's copyright law. That's not YouTube. That's YouTube staying within its safe harbor. I'm not defending YouTube. I don't like to defend YouTube too much, but I mean, let's be realistic here. YouTube has to follow the law. On November 19th, 2016, Benjamin sent Hughes an email requesting that she withdraw the takedown notice. I often say this is a good idea. Talk to your opponents before you go into litigation or further legal action. And on the same day, Benjamin also posted the Levels of Awareness video to his Twitter account, where it remained publicly accessible until his account was suspended on August 9th, 2017. I'm not going into that. I don't know anything about why his account was suspended, whether it was legit or not, so I'm not judging anything there. I'm just going to talk about the copyright issue in this case. On November 22nd, 2016, after Hughes declined to withdraw her notice, Benjamin sent YouTube a DMCA counter notification, which is the proper response if you believe that, if you have a sincere good faith belief that the the original takedown notice was improper or was a misrepresentation, then you send a DMCA counter notice, and that takes it out of YouTube's hands, or at least it's supposed to. I have videos about this. YouTube doesn't always observe counter notifications for some reason, especially with music claims. But in this case, YouTube would have put the video back up, or was supposed to put the video back up within 10 business days or 14 calendar days, something like that. So he sent a counter notification claiming that SJW levels of awareness was entirely transformative and intended for parody. Benjamin also stated under penalty of perjury that he had a good faith belief that the levels of awareness video was removed due to a mistake or misidentification of the material to be removed or disabled. Hughes alleges that YouTube relied upon Benjamin's counter notification to reinstate certain features of their service, including allowing for the continued public display of the video, though she does not specify when YouTube reinstated access. So it does look like YouTube relied upon the counter notification and reinstated access to Benjamin's video. So then here's the procedural history of the case. I'll see if there's anything worth skipping here, but otherwise we're going to read through it. Hughes initiated this action August 25th, 2017. Her complaint sets forth 2 causes of action: copyright infringement of the "We Thought She Would Win" and that in the YouTube video and the Twitter video, and that he engaged in a DMCA misrepresentation himself. So we have sort of countervailing 512F complaints here. 512F is for misrepresentations. Again, if both parties have a sincere good faith belief that they are right, the law actually doesn't allow for recovery of damages. But if the DMCA was sent without a sincere good faith belief, with willful blindness, known or should have known level of knowledge, then you can usually recover your actual damages. I'm not sure about attorney's fees. I think attorney's fees are in there with that one. But remember, we just saw a video where you don't get your attorney's fees and you don't get your costs for unregistered infringements, even if new infringements occurred after you registered, if they were in the same vein. That's our Fifth Circuit video from a couple days ago. And that misrepresentation was done by stating in his YouTube counter notification that his video was a fair use, transformative, and intended for parody. On April 20th, 2018, Benjamin filed a motion to dismiss Hughes' complaint pursuant to Rule 12b-6, failure to state a claim, upon which relief can be granted. So it's not just failure to state a claim. She obviously states a claim, but is it a claim that through the operation of law, relief or remedy can be granted? And no, the judge says no, there is no relief here for Hughes because that claim is not a valid claim. So it failed to state a claim. Hughes filed an opposition May 18th, 2018, and Benjamin filed a reply May 30th, 2018. On June 7th, 2019, Benjamin submitted a one-page letter in support of his notice to dismiss, apprising the court of supplemental authority. We didn't actually read any of that, but take a look at the time frame here. This was filed in August of 2017. It happened in November of 2016. The motion to dismiss was April 20th, 2018, and it still hadn't been ruled on in 2019. It just sat there for like a year, I guess. To survive a motion to dismiss pursuant to 12b-6, the complaint must provide the grounds upon which the claim rests. Specifically, a plaintiff must allege enough facts to state a claim to relief that is plausible on its face. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. And take a look at some of these cases. They're citing some very, very important cases. Law students, if you're looking for cases to read, you're going to be reading these in your either evidence class or jurisdiction class or procedure class. In reviewing a motion to dismiss under 12b-6, a court must accept as true all factual allegations in the complaint and draw all reasonable inferences in favor of the plaintiff, which is Akilah Hughes here. Am I getting that right? Yeah. Yeah, hers is Benjamin. I forget what his last name is. Carl Benjamin. That is his last name. However, the tenet is inapplicable to legal conclusions. Thus, a pleading that offers only labels and conclusions or a formulaic recitation of the elements of a cause of action will not do. If the plaintiff has not nudged its claims across the line from conceivable to plausible, its complaint must be dismissed. So this does not even reach the summary judgment standard, does not get to a jury trial, does not get to an adjudication on the merits, because she doesn't even state enough of a legal claim to survive that favorable to the plaintiff standard. So the discussion or analysis. The court will address Hughes' claims of copyright infringement and DMCA misrepresentation in turn. To establish a prima facie or basic case of copyright infringement, a plaintiff must demonstrate 1. Ownership of a valid copyright, and 2. Copying of constituent elements of the work that are original. And this quotes the Feist Publications v. Rural Telephone Services case that we just went over a few days ago. I forget which video that was. I think it was the it was the Star Trek videos. If you were interested in the Star Trek versus Space Force logo thing, we just released a video on that yesterday. A defendant is deemed to have copied constituent elements of the plaintiff's work where the defendant has actually copied the plaintiff's work and the copying is illegal because a substantial similarity exists between the defendant's work and the protectable elements of the plaintiff. The defendant can defeat a prima facie showing of infringement, however, by proving that the doctrine of fair use permits his or her employment of the plaintiff's work. So fair use is a defense to copyright infringement. Technically, it's a legal right of copyright, just like any of the Section 106 rights are, and that's from the Lentz v. Universal case. Although fair use is an affirmative defense, and thus the defendant bears the burden of proving it, fair use can nevertheless be adjudicated on a motion to dismiss. At this stage of the litigation, the court's task is to determine whether the facts necessary to establish the defense are evident on the face of the complaint, including any materials properly incorporated into the complaint, which here, those properly incorporated materials include the videos. In undertaking a fair use analysis, the court considers the following non-exhaustive list of factors set forth in 17 U.S.C. 107. We go over these all the time, but it bears repeating. 1, the purpose and character of the use, including whether such use is of a commercial nature or for nonprofit educational purposes. The nature of the copyrighted work, the original. The amount and substantiality of the portion used in relation to the original copyrighted work as a whole, and the effect of the use, the secondary use, upon the potential market or value for the original work. As the Second Circuit has explained, the 4 listed statutory factors guide but do not control the fair use analysis and are to be explored and the results weighed together in light of the purposes of copyright. The ultimate question of whether the copyright law's goal in promoting the progress of science and the useful arts would be better served by allowing the use than by preventing it. What a great opinion this is. I love it when judges take the time to write a proper fair use or proper copyright opinion, because it just reads like a story from beginning to end, which is why I love presenting these to you. The court will now consider each of the above statutory factors. The first factor, the heart of the fair use inquiry. So the first factor is the heart of the fair use inquiry, concerns the purpose and character of the allegedly infringing use. In the preamble to Section 107, Congress identified criticism, comment, news reporting, teaching, scholarship, and research as illustrative purposes of fair use. Additionally, the commercial use of a new work may weigh against a finding of fair use which favors nonprofit educational purposes. But because nearly all of the illustrative uses listed in the preamble of 107 are generally conducted for profit in this country, courts do not give much weight to the fact that a secondary use was for commercial gain. Instead, the critical question when applying the first fair use factor is whether the new work is transformative. So when you hear transformation, copyright transformation, well, it's transformative, therefore it's a fair use. That's just one of the four factors, and you can't just stop there and go, well, my work was transformative, therefore. No, your therefore can really only be I win one of four factors if you truly believe it was transformative. Like the overall fair use determination, whether a work is transformative is an open-ended and context-sensitive inquiry based on how the work in question appears to the reasonable observer. The critical inquiry is whether the new work uses the copyrighted material itself for a purpose or imbues it with a character different from that which it was created. Different from that for which it was created. So new purpose, new character, different from that for which it was created. Most relevant here, a new work may be transformative even where it consists entirely of portions of the original work. That's really important. Or indeed, where it is an exact replication of the original work. A secondary work can be transformative in function or purpose without altering or actually adding to the original work. For example, the court found in Baraban versus Time Warner that the first statutory fair use factor weighed heavily in favor of fair use, where the defendant had copied the plaintiff's photo outright in order to comment on it and on the advertising campaign in which the photo played an integral part. The court noted that the defendant's use of the photo was not exactly parody or satire, as those terms have been defined in case law, but that the defendant's use of the photo in context, as part of a book containing critical commentary, nevertheless clearly fell within the permissible use categories of comment and criticism. Here, it is clear from the face of Hughes's complaint that Benjamin copied portions of We Thought She Would Win for the transformative purposes of criticism and commentary. Beginning with the title of Benjamin's work, SJW Levels of Awareness, Hughes herself acknowledges that SJW, or social justice warrior, is a term routinely used by Benjamin in a demeaning context to belittle proponents of perceived liberal social policies and stances. Although Hughes contends that her own subjective awareness of the term's meaning does not establish that a reasonable observer would interpret the term SJW in a pejorative manner, the court concludes that SJW, or social justice warrior, has sufficiently entered the modern lexicon such that there can be no serious dispute as to its pejorative meaning in this context. So literally, the fact that it's a mean thing to say shows that it's more than just some meaningless level of commentary, but it's actually criticism, which is exactly what fair use is for. And they actually go look at the dictionary definition for SJW, which they say is a person who expresses or promotes socially progressive views. A derogatory term. I was like, that belonged in there someplace. Derogatory term for a person who expresses or promotes socially progressive views. See also Nix v. Hayden, an 1893 case explaining that dictionaries are admitted not as evidence but as aids. Okay, sorry, never mind. And levels of awareness is plainly used in a sarcastic manner, so SJW, levels of awareness. So the levels of awareness title is plainly used in a sarcastic manner, and when combined with SJW implies a lack of awareness concerning social or political matters. Moreover, and the judge does note that they take judicial notice of news articles and other things. That's okay. Never mind on that. Moreover, the critical nature of SJW levels of awareness is apparent from the broader context of Benjamin's YouTube channel where it was posted. As the complaint alleges, Benjamin routinely engages and criticizes viewpoints on various social and political issues on his YouTube channels, specifically targeting topics such as feminism, the left, Black Lives Matter. Thus, whether SJW levels of awareness is accessed by searching for that related content on YouTube or by going directly to Benjamin's YouTube channel, a reasonable observer who came across the video would quickly grasp its critical purpose. Furthermore, although courts have found transformative uses even in cases involving exact copying, the court notes that SJW levels of awareness is not an exact copy of We Thought She Would Win. Rather, Benjamin excerpted We Thought She Would Win to depict the specific moments he felt exemplified Hughes's political identity and lack of awareness. For example, Benjamin included Hughes's prediction and hope that Secretary Clinton would win the election while omitting footage that did not support his message, like Hughes's statement that Secretary Clinton won the popular vote with record numbers. And he excluded content unrelated to his criticism, like Hughes's commentary on the societal benefits of YouTube. In this way, Benjamin excerpted We Thought She Would Win to maximize his criticism of Hughes' liberal viewpoint. And there's another footnote here. To the extent that Benjamin's selective excerpting was not fair to Hughes in the colloquial sense of accurately conveying her level of awareness, courts will not, except in rare circumstances, reject a fair use defense based on inaccuracy. So the accuracy of the commentary is not at issue here. It is whether it meets the copyright fair use test, not some concept of fairness. Not the same thing. Finally, although the commercial nature of an allegedly infringing work is not necessarily a significant factor, the court notes that the complaint barely mentions the commercial or non-commercial nature of levels of awareness. At most, the complaint alleges generally that defendants have unfairly derived profits from levels of awareness in the form of advertising revenues generated from its upload to and availability on YouTube, and from increased popularity of their YouTube channel asserted to SJW levels of awareness. The complaint, however, does not specify how the increased popularity of Benjamin's YouTube channel commercially benefited Benjamin himself, nor does the complaint indicate whether the referenced advertising revenues accrued to Benjamin or to YouTube, or I guess both is what really would have happened. In any event, insofar as there is a commercial awareness to levels of awareness, I said awareness, if there is a commercial aspect to levels of awareness, it pales in significance to the considerations discussed above. Although there is no question that the defendant's artworks are commercial, we do not place much significance on that fact due to the transformative nature of the work. Because a reasonable observer would plainly infer from the title of the video, the context in which it was posted, its selective copying, that it was intended to criticize Hughes and comment on her perceived lack of awareness. Because of this, the first fair use factor favors Benjamin. On to the nature of the copyrighted work. The second fair use factor, the nature of the copyrighted work, calls for recognition that some works are closer to the core of intended copyright protection than others, like works intended for creative expression and for public dissemination. Applying this factor, courts consider, 1, whether the copyrighted work is expressive or creative, with a greater leeway being allowed to a claim of fair use where the work is factual or informational, and 2, whether the work is published or unpublished, with the scope for fair use involving unpublished works being considerably narrower. So in other words, don't make a criticism or commentary or fair use of an unpublished work unless you really know what you're doing, because that's a much narrower consideration. The second fair use factor, however, may be of limited usefulness where the creative work of art is being used for a transformative purpose. So in other words, the second fair use factor weighs less in the four-factor analysis when the secondary work is made for a transformative purpose. See Bill Graham Archives versus Dorling, Kindersley, and Campbell. I'm assuming that's Campbell v. Acuff-Rose Music, but there is another Campbell out there. Explaining that the nature of the copyrighted work is not much help in separating the fair use sheep from the infringing goats in a parody case. That's funny. Parodies are almost invariably a copy of publicly known expressive works. Here, the second fair use factor is essentially neutral and of little importance. As for the first Blanche consideration from the Blanche case above that we didn't really go over the site, Hughes's work is factual and informational in that it provides a first-hand account of a newsworthy event, but it also has expressive or creative value in both its commentary and production. With respect to the second Blanche consideration, We Thought She Would Win is a published work, and thus the scope of fair use in this context is not considerably narrower than it would be if it had been unpublished. Given these countervailing considerations and the fact that levels of awareness is plainly transformative, the second fair use factor has little impact. So we're still on Benjamin's side here after the second fair use factor. So then the third factor turns on whether the amount and substantiality of the portion used in the secondary work in relation to the original work as a whole is reasonable in relation to the purpose of its copying or of the copying. In assessing this factor, the court considers not only the quantity of the materials used, but also their quality and importance. The crux of the inquiry is whether no more content was taken than necessary, given the purpose and character of the allegedly infringing use. The third fair use factor inquiry must take into account that the extent of the permissible copying varies with the purpose and character of the use. Thus, the third factor may favor defendant even where the defendant copies an entire work, provided that such copying was reasonably necessary in relation to the work's transformative purpose. Here, the levels of awareness video copied 20% of We Thought She Would Win, a percentage which, while greater than that found unreasonable in some cases, was still far less than the entire video. In addition, although the selected excerpts were important to Hughes's video, they were also linked to the critical purpose of SJW levels of awareness. As noted above, Benjamin did not copy parts of Hughes's video that undermined or were unrelated to the critical purpose of levels of awareness. Notably, Benjamin also did not copy every part of We Thought She Would Win that evinced Hughes's progressive views. Rather, Benjamin copied as much of We Thought She Would Win as was deemed reasonably necessary for him to convey his critical message. In these circumstances, the third factor tips in favor of Benjamin. So we're still very much in favor of Carl Benjamin or Sargon of Akkad. The fourth fair use factor, which is one of my favorite factors, I like the first and the fourth. The fourth fair use factor is going to be the market usurpation factor. Whether the secondary use usurps the market for the original work. A defendant usurps the original work's market. I love that word, usurps. It's just such a weird word. Usurps the original work's market when the infringer's target audience and the nature of the infringing content is the same as the original. Thus, the more transformative the secondary use, the less the likelihood that the secondary use substitutes for the original. Here, there is no danger that SJW levels of awareness will usurp the market of progressive commentaries such as We Thought She Would Win. Benjamin's target audience, generally political conservatives and libertarians, is obviously not the same as Hughes's target audience, generally political liberals. Moreover, although SJW levels of awareness is comprised entirely of portions of We Thought She Would Win, there is no reason to think that Hughes's audience will abandon her progressive YouTube channel to watch the derisively titled Levels of Awareness on a conservative YouTube channel simply because it contains parts of her work. Thus, the fourth fair use factor, like the first and third, favors Benjamin. Because 3 of the 4 statutory fair use factors favor Benjamin, including the most important factor, number 1, the purpose and character of the use, and the least important factor is the nature of the copyrighted work is neutral, the court concludes that the fair use defense clearly applies on the face of Hughes's complaint and a review of the videos themselves. Accordingly, Hughes has failed to state a claim for copyright infringement. Boom! So that's the end of her copyright infringement claim, but the court still has to dispose of the DMCA misrepresentation claim, and we're going to get a couple quotes in here that I really, really like. The DMCA allows online service providers to avoid copyright liability if they comply with the procedures in 17 U.S.C. 512. See Lentz v. Universal Music, the Ninth Circuit 2016 case that confirms that fair use is a statutory right. Specifically, a service provider may avail itself of the safe harbor provisions in Section 512 by expeditiously disabling access to allegedly infringing material upon receipt of a so-called takedown notice. A copyright owner who submits a takedown notice must include a statement under penalty of perjury that she has a good faith belief that use of the material in the manner complained of is not authorized by the copyright owner. In response, the creator of the allegedly infringing work may file a counter notification in which the alleged infringer must attest under penalty of perjury that the subscriber has a good faith belief that the material was removed or disabled. When they say subscriber, I think they mean the author of the alleged infringing work was removed or disabled as a result of mistake or misidentification of the material to be removed. Upon receipt of the counter notification, the service provider, okay, so they mean subscriber of the service provider, the service provider can again avoid liability by restoring access to the allegedly infringing material in 10 to 14 business days. However, any person who knowingly, materially misrepresents under this section that material is or activity was removed or disabled by mistake or misidentification is liable for damages, including costs and attorney's fees incurred by the copyright holder as a result of the service provider relying upon the misrepresentation in replacing or the removed material or ceasing to disable access to it. Here, Hughes alleges that Benjamin knowingly and materially misrepresented his counter notification that SJW levels of awareness was a fair use and was entirely transformative and was intended for parody. These allegations fall short. Benjamin's implied statement that his video constituted fair use was accurate for the reasons stated above in this opinion and order. As a court in this district explained, it is self-evident that a misrepresentation As a court in this district has explained, it is self-evident that a statement cannot be a misrepresentation for purposes of the law if it is factually accurate, and that is quoted from the Matt Haas v. Hila and Ethan Klein H3H3 case, which is awesome that we get to see that cited again and again and again for fair use. It means that it was a good idea for them to go to court and establish basically a legal precedent that is now being cited in dozens, if not eventually hundreds, of fair use cases. The same is, of course, true for statements that are legally accurate. Benjamin did not misrepresent that his video was transformative. Whether it was entirely transformative, as stated in his counter notification, or just merely transformative, the statement is immaterial as a legal matter. There's an example here in the defamation context. A plaintiff's exaggeration was mere hyperbole or matter of opinion and not false. So the fact that he said it's entirely transformative does not change anything. Last, the complaint fails to plausibly plead a misrepresentation in the form of Benjamin's statement that it was intended for parody. Even if levels of awareness was not, strictly speaking, parody, as that term has been defined by case law, the difference between parody and non-parodic copying for the purpose of mocking criticism is subtle, and ultimately immaterial here. Moreover, it is implausible to suggest that Benjamin knowingly adopted one of these two characterizations over the other in an effort to mask his intentions. Because the complaint, therefore, does not plausibly allege that Benjamin made misrepresentations in his counter notification, let alone knowing and material misrepresentations, Hughes' DMCA claim fails. For the foregoing reasons, it is hereby ordered that Benjamin's motion to dismiss is granted. Although Hughes has not requested leave to amend the complaint, the court notes that leave to amend would be futile. The court's analysis above is principally based on its review of the two works at issue and the context in which they were posted, rather than any allegations that may be refined in amended pleadings. Thus, the dismissal is with prejudice, and the clerk of court respectfully is directed to terminate the motion pending at document number 30 and close the case. And that's Judge Richard Sullivan, yesterday, February 3rd, 2020, New York, New York. Holy mackerel, that's exactly what we were hoping for. It's not that I don't see why the parties were upset at each other. It's that the law doesn't care whether you were upset at each other. The law cares whether you followed the law. And Sargon, Carl Benjamin, followed the law of fair use, made a transformative use of the original work, of Akilah's work, and her reaction was inappropriate, at least legally speaking. I'm not saying she didn't have some reason to be upset in the larger sense, but that doesn't mean that she has a legal right to deny the criticism and commentary. The whole reason for fair use is because people wouldn't allow criticism and commentary, fair uses of their material. They would instead make something themselves, or they wouldn't allow the criticism to be made of themselves. Obviously, she did not want this kind of criticism. It clearly points out how starry-eyed the political people were on one side about the victory that they expected. I remember some sites were saying 95% chance that the Democrats would win the 2016 election, and I remember the crushing defeat that they all experienced when it turned out that their political campaigning had failed. And we can go into all of that. Not on YouTube, not on my channel, where we try to remain politically neutral. Stuff happened the way it happened, and Sargon pointed out the starry-eyedness and unawareness with which that campaign was run, or at least in his opinion, how it was run. So we got the result that we did, and here we are. We're almost in the next campaign. I mean, Iowa was literally yesterday, and there's already more controversy about how the votes are being counted. There's this app literally made by a company called Shadow. Do we really you name your vote counting app Shadow? That's just some kind of tone deafness, but again, not for this discussion. Anyway, so this is a victory for fair use, and I am not at all disappointed. This was a spectacular opinion by Judge Sullivan, and I am really proud that we were able to bring this to you. I hope that you enjoyed our video. I'm going to take it out because I actually have lots of work to do today, and I need to get back to what I'm supposed to be doing. So let me take out my show and let you get on with your day as well. Thank you very much for joining me. This is Lawful Masses, your favorite legal news and education program. This is a community-supported legal education channel, and we would not be possible without your financial support. Please consider donating to us on patreon.com/ljfrench or sponsors.com/law. I have tallied the February 2020 sponsors and Patreon supporters. At the $50 level, I want to say thank you to Aspernari, to Video Demonetized, welcome, new supporter, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Steven, Cute Grills in Your Area, Ottah, Kysal, and Longreach Jones. There are two more brand new supporters at the end there. Really appreciate you. The $5 plus supporters are in the description of the video below. I love you all. I am Leonard French, your favorite copyright attorney. I will see you in the next video. We're going to go over Judge Reineker's improper traffic stop, where he got himself out of a traffic stop by asserting his authority as Chief Judge of Lancaster County Court of Common Pleas in Pennsylvania. And he got reprimanded for it, but it's kind of a public reprimand, and you'll see what happened there, and nothing else is really happening to him. So we'll see about that tomorrow. Until then, enjoy, love you all, have a good one, bye.